So thank you very much, first of all, for inviting me to speak here, and thank you for your introduction. And may I say how tremendously sorry I am, of course, that I can't be in Maribor. And I hope that I'll be able to see you all again in person very soon. And thank you for mentioning the book. It's actually not quite published yet because it turned out to be longer and more complicated than I anticipated, but it's due to be published, I think, hopefully later this year. I've just sent back some proofs now. So I hope some of you might enjoy that. So I understand that my brief was to talk about the situation in terms of recognition and enforcement of judgments in the UK after Brexit. So I want to do a brief overview of the situation now. So it's a sort of bird's eye view of the situation in the UK for movement of judgments from other member states after Brexit. And the problem, of course, is that there is no longer any reciprocity. So the Brussels I regime is built on the idea of there being reciprocity, that all member states are assuming jurisdiction on the same grounds. And because all states assume jurisdiction on the same grounds, then it's also possible to have confidence in the judgment and to recognise and enforce that judgment. So outside that regime, the UK no longer has any assurance about the rules of jurisdiction used in other EU member states. And I think it's probably worth highlighting there the point that really has been made in a couple of these presentations so far about mutual trust. So that the absence of mutual trust means that the UK and the lack of development of mutual trust over the years in which the UK has been a member of the EU has meant that there is no foundation on which the UK feels confident that other member states would assume jurisdiction only on appropriate grounds, and that it doesn't have the confidence in the judgments that will result, which is, of course, an enormous shame. The UK has always wrestled to some extent with the Brussels regulations approach to jurisdiction and recognition. You are probably aware of the fact that the UK's approach to jurisdiction is very much one where there is a lot of exercise of discretion. So our laws allow, in principle, quite wide-ranging assertions of jurisdiction on the basis of different connections between the dispute or the people involved and the England or Scotland. We have separate jurisdictions within the UK, of course. But in spite of that possibility of an extensive use of jurisdiction, then the courts have a discretion to refuse to hear cases if there isn't an appropriate connection with the UK. So it's the courts can look at the situation on the particular facts that have arisen, and they are keen that jurisdiction should only actually be exercised where there is an appropriate connection, where the England, I'll use England as the example, is the forum conveniens. And so because of that approach to jurisdiction, the UK has always struggled to some extent with the Brussels regime. So on leaving the EU, the approach has been adopted that rather than have some new rules or some special approach towards EU member states, the UK would treat EU member states in the same way that it treats other countries, and it would use its traditional rules for that purpose. So there is an enormous amount of legislation arising out of Brexit. I have to say that I've tried studiously to ignore it. So most of my research has moved very much in the direction of comparative law rather than private international law. But the relevant provisions here are particularly to be found in the Civil Jurisdiction and Judgments Amendment EU Exit Regulations. We have delightful titles for the legislation, adopted in 2019. So the main effect of the regulations is to remove the Brussels regime from domestic law. So we've retained certain aspects of it, particularly, again, because there's more than one jurisdiction within the UK, and so some of the concepts and ideas from the Brussels regimes have been used in intra-UK cases, and some of that has been retained. So particularly provisions relating to consumer and employee matters and rules on the domicile of corporations. That means then that going forward, the recognition and enforcement of judgments is determined by essentially 3 sets of rules at the moment and possible future additions to that. The common law rules, so the laws which are based on case decisions going back for mainly about a century and a half, some statutory registration systems, and the 2005 Hague Convention on the Choice of Court Agreements. The UK, I think, has been hoping very much to be able to participate in the Lugano Convention, and towards the end of this presentation we can look at the prospects for that. And of course there's the new Hague Judgments Convention, which may be an option at some point in the future, but that so far only has 3 signatories and is not likely to come into force for the foreseeable future. So if we look at the common law rules, first of all, the traditional common law approach to recognition and enforcement of judgments, then there is no specific procedure for recognizing a foreign judgment. There's no executor procedure. And registration, we'll look at in a moment, registration can take place under specific statutory regimes. So as a result of that, it means that if there is a foreign judgment, it's necessary to begin new proceedings in England or Scotland to enforce the foreign judgment. So the foreign judgment is taken to be the source of a debt, and essentially you're bringing an action in England to enforce a debt using the judgment as evidence of the existence of that debt. We have a summary procedure for reaching judgment under the Civil Procedure Rules, Part 24. So you can apply for summary judgment if the defendant has no real prospect of successfully defending the claim. Obviously, the existence of a judgment is very good evidence of your claim. So in principle, summary judgment can often be achieved, but there are a list of defences that might be available to that, which I'll look at on the next slide. I just wanted to highlight the fact here that this approach to recognition and enforcement is significant in practice, not least because of the impact that it has on the fees that are payable. So because new proceedings are required, there are substantial court fees that would need to be paid in order to bring those proceedings, in addition to any additional costs for hearings and so on. So if you've got a judgment that's over £200,000, then it's a £10,000 court fee in order to bring the proceedings to enforce the debt. So there's a list of possible defences then to the claim that's being brought to obtain recognition or enforcement of the judgment. First of all, the common law rules only apply to monetary judgments, so they only apply to debts. It's not possible to enforce a non-monetary judgment through this way. And a judgment has to be final and conclusive on the merits in the court of origin. The approach of English law to finality is not really the same as in European jurisdictions, because we don't have the concept of ordinary appeals. So it's possible for the judgment of a first instance court to, even if it's subject to appeal, to be seen as final for the purposes of English law, but it would be possible to obtain a stay of proceedings to await the outcome of an appeal. One of the most discussed issues, I suppose, in relation to the proceedings in the foreign court would then be whether the foreign court has jurisdiction according to the English rules or Scots rules if it's being enforced in Scotland. And I'll look at those on the next slide. So there is a difference between the rules that the English courts would adopt if they are asserting jurisdiction,